Hey guys, welcome to this video. This will be a follow-up to what we did in yesterday's video, which was Burns versus Warehouse. That was a Fair Credit Reporting Act case. If you remember, the issue there was my account's been charged off, so it should not show a monthly payment due. The whole amount's still due, but not a monthly payment. And that was a case from August 19. And the court there referred to a case in February of this year from Georgia called the Tammy Keith versus Equifax case. And the court said, well, the result in the Keith case doesn't mean I have to find the same result. And so I point out, when the defendant files something saying, hey, here's a case from another court that shows I should win, you got to go read that other case. So we're going to read this case, and we'll learn a couple things in here. One, this case, at least as a judge presents it, and I've not gone back and looked at the complaint or read the briefs here, I'm just going with what the judge says. It doesn't sound like the case was pled in the best possible way. And we'll see that the defendant here, we're going to focus on this Founders Federal Credit Union. This would be a furnisher under the Fair Credit Reporting Act because they furnish information to the credit bureaus. They file a motion to dismiss, and the plaintiff did not even respond to it, which I don't know why. That's pretty bizarre. And so it's kind of like the judge only had one side of the argument here. And so let's look at what's happened here. We've got a case brought against a couple of the bureaus, but we're not going to focus on them. Instead, it's against Founders for violating Section 1681 S2B. This is the section of the FCRA where you make a dispute to the credit bureaus. They then notify the furnisher of the information saying, hey, the consumer says something's wrong. Then that furnisher, only at that point, only after they've been notified by the credit reporting agencies, do they have an obligation to then investigate your dispute. And if they don't do that investigation properly, then you can sue them under the Fair Credit Reporting Act. And so we have currently before the court is defendant Founders motion to dismiss complaint. Plaintiff, who is represented by counsel, failed to file any response to this motion. I have no earthly idea why. I can't imagine being in federal court and not responding to this. So the court says, here's the basic gist, and this will be like that Burns case we talked about yesterday, inaccurately reporting its trade line with a monthly scheduled payment of $152. Plaintiff says Founders accelerated the payment schedule, closed the account, so it's charged off and closed. So I don't have an obligation to make monthly payments. Now, they'd still owe the total amount. They're just saying, I don't have an obligation to make the monthly payment, so you should show the scheduled monthly payment of $0. Or I would probably change that to say, make it blank. Okay. And then she says, hey, I pulled my credit reports and I sent dispute letters to Equifax TransUnion. That's wonderful. That's what you have to do. You have to notify the credit bureaus. What we're going to see is, my hunch is that these were not sent by certified mail. Instead, these were just mailed. And I'll be honest with you, I've been suing the credit bureaus for, I don't know, maybe 2003 or 4, something like that. Maybe even earlier than that. So, 20 years or so. If you send it by regular mail, they're going to get that letter, and I bet you they just throw that away. Every client I've ever had come to me who said, I mailed a dispute letter just by regular mail, they never got anything back from the credit bureaus. They just throw it away because you can't prove they got it. You have to be able to prove the credit bureaus received it. You have to assume the credit bureaus will lie and will break the law with no remorse. It won't bother their conscience in the slightest. So understand they lie. That's just what they do. So make it to where they can't lie about getting your dispute letter. So she says, I sent the dispute letter, and then upon information and belief, I think they sent it on to Founders, which is their obligation under the law. But here's the weird part. Having not received the investigation results. Okay, let me just stop there. That's bizarre, Because if you send it by certified mail and you can prove Equifax and TransUnion got your dispute on, I'm just making this date up, June 1st, and now it's more than 30 days, you don't have results back. Well, you pick up the phone, you call them. Say, hey, you guys got my dispute letter on June 1st. I got the green cards where you signed for it. I never got the results back. And the credit bureaus will say, oh, well, we mailed that. Let us mail it to you again. And then you get it. Or if they say, no, we didn't get your dispute letters. Well, you prove that they did. Now, you might send another one, or you might just sue the credit bureaus. Because if you send it by certified mail and you can prove they got it, then either the credit bureaus have totally messed this up by not actually doing an investigation, in which case you got a great case against them, or they did get it and they did investigate it and there's just been some mess up in the mail between you getting it from the bureaus. And so you call them. I haven't read the lawsuit, but I don't see where that happened here. Instead, it says, because I didn't get the investigation results, I just pull my credit reports and it doesn't show it. Well, you need to get the actual results of investigation from the credit bureaus. Make them send that to you. And so again, got to do it by certified mail. I know I keep repeating that, but I mean, probably every 10 people I talk to, actually I'd say this, every 20 people I talk to, maybe one person will have done their disputes by certified mail. And it's just, so I'm constantly telling this to people, like, hey, we got to redo this because we got to be able to prove this. And so please do your disputes by certified mail. So in count 1, the plaintiff says you violated this law in a negligent way because you didn't properly investigate it, you didn't review all the information, which is a reason why we often send a copy of the dispute letter, again by certified mail, so we can prove they got it. A copy of the dispute letter to the furnisher so that if they say, well, the credit bureaus didn't give us all the information from your dispute, we go, yeah, but I sent you a letter. That was in your file. And then they also say they failed to direct the credit bureaus to report it, monthly payment. And then the second count, they say, well, that's a willful violation. And as was stated above, the furnisher filed motion to dismiss. And remember, the plaintiff did not even respond to this. So let's go down to the discussion. Here's the purpose of the Fair Credit Reporting Act: to protect consumers from having inaccurate information about their credit status circulate. Well, why is that a big deal? Because you need accurate information to protect your reputation. And so when you dispute the accuracy of something to the credit bureau, and oftentimes these are called CRA for Consumer Reporting Agency. We call them credit reporting agencies, credit bureaus, it's all the same thing. The CRA must notify the furnisher of the dispute. And then once that happens, the furnisher has to investigate and respond to the dispute. And so here's kind of the summary of it. Affirmative duty, conduct investigation. If you find as the furnisher it's incomplete or inaccurate, you must report those results and make any changes. So what does that mean as a practical matter? When you're the plaintiff suing, you have to allege furnisher got proper notice. And then, so we've got and then failed to uphold one of its duties. And you can see here we got number 1, failed to investigate. Number 2, failed to review all the information. Failed to report the investigation. And then if it's inaccurate, incomplete, or cannot be verified, failed to modify, delete, permanently block. And Founders says, well, all the plaintiff did was just lay out those elements. In other words, they just like copied and pasted from the statute. And the court says, I agree. And first, the plaintiff fails to allege Founders received proper written notice. Okay. So here, plaintiff did not allege he notified Founder of any inaccuracies. I'll say this, and I don't know this particular judge, and this may just be sort of an offhand statement. If the plaintiff had alleged he notified Founders, that's not good enough. The only way you get liability is the notice must come from the credit bureaus. So it's consumer to credit bureau to furnisher. It's got to be in that pattern. Now, you can also go consumer around to the furnisher, and that can help, but it doesn't establish it. So the plaintiff says, well, I notified Equifax TransUnion, asked them to report, and they have a duty to forward that to founders. And so I think that they did. And the court says, well, this sort of upon information and belief, I don't have to rely on that. So here's the way that we do it. Now, I don't know how the plaintiff did it here, but I'll tell you how we do it. And the first time I remember this being an issue was back in about 2006. We sued Capital One and the credit bureaus. And Capital One filed a motion to dismiss and said, well, you can't show that we were notified by the credit bureaus. And we said, well, read our complaint. We said, on the one hand, well, first let me back up. We laid out, all right, we sent these disputes. Here's when Equifax got it, Experian got it, TransUnion got it. Certified mail, here's who signed for it. Then we said, in each one of those companies, within the statutory period, I think it's 5 days, notified Capital One, the furnisher. And then we said in the next paragraph, alternatively, the credit bureaus did not notify Capital One. We said, well, that's inconsistent. Yeah, it's absolutely inconsistent. We even put a footnote and said, this is inconsistent. We know that before the defendant has a complete come apart. Remember, under the rules, this is Federal Rules Civil Procedure 8, it says you can freely plead things that are inconsistent. And so, and we point out, what the credit bureaus did and what Capital One did and how they notified each other, we can't know that for sure until we get people swearing under oath. So we're pleading both sides of it. Now, if Capital One was notified, then we have these obligations here under 1681 S2B. But if they were not notified by the credit bureaus, then we've got a great claim for violating the Fair Credit Reporting Act against the credit bureaus. We don't really care which one it is. We just are pleading both sides of it. So that's how we do it. And the court says, well, even if I find that founders had notice, you fail to allege any factual allegations to show they failed to uphold their statutory duties. You just say that they did this wrong and you've pled absolutely no facts. So here's how I would do this. I would say in the dispute letter and in the lawsuit, just spell it out. Say, look, this thing was charged off or accelerated. There's now no longer a monthly payment due. Great. No monthly payment due. But you're reporting that I have a monthly payment due. And that's inaccurate because, first of all, I don't have a monthly payment due. And if a creditor that's looking at me for credit totals up all of my monthly obligations, it's going to distort those because it's going to put in there, I think this was like $150. I think the Burns case we did yesterday was, $70? And so you point out why this is a problem. And you say, in the lawsuit, you say that the furnisher, Founders Credit Union here, the furnisher, they knew that I had no monthly payment because they're the one that charged it off. They're the ones that accelerated it. Nobody else in the world would know this but them. And so they know this, and they got the dispute from the credit bureaus, and I sent them a copy of the letter, clearly telling them what the problem was. If they did an even terrible investigation, they would have come to the conclusion, oh, well, we can't report that you have a current monthly obligation when you don't have a monthly obligation. Now, this is assuming the theory's right. I'm not discussing whether the theory's right here. I'm just saying this is how you would do it. And then you would say, and so they would have to come back with, okay, we are reporting this as no monthly payment or zero monthly payment. So you got to lay it out. Okay, if you paid off an account and they're reporting a balance and you dispute it, you can't just say they failed to do a reasonable investigation. You have to say, here's why they failed to do a reasonable investigation. Because on X date, whatever, the debt collector, Bank of America, Capital One, whoever it is, on X date, they got my payment of $5,000 and that fully paid off the obligation. And it cleared my bank on this date, and then I disputed it. And so there's no way they could come up with anything other than showing that the account is now paid off. So you want the judge to go, well, yeah, that makes perfect sense. And at least according to the judge, the plaintiff did not do that here. They just kind of copied and pasted from the statute, and that doesn't work anymore. So the court says, I'm going to dismiss the claims against them, and I'm going to grant the motion to dismiss the claim. But it's kind of interesting, the judge does it without prejudice, which it's like it never happened. The lawsuit never happened against Founders. So the plaintiff could plead it again, could bring that lawsuit again. Now, it may be the judge was saying, this is weird that there was no response to this, and as a result of that, this is why I'm doing it this way, giving you a chance to correct your complaint. Because there's a general principle that there's a motion to dismiss saying that you didn't plead your complaint right, you should have an opportunity to fix that. Now, this judge was really nice about it. A lot of judges would say, well, you didn't respond, so I'm dismissing it with prejudice, and now you're done against that company that you sued. So here the judge is giving the plaintiff kind of a second chance, and the judge is saying your case will proceed against Equifax and TransUnion. So anyway, I hope that this was helpful to you, and feel free to leave any comments below. And if you have any particular cases you want me to take a look at, just put those in a comment or get with me directly, alabamaconsumer.com, or you can email me, john@wattsherring.com. It's WATTSHERRING.com. And I will catch you guys in the next video. Thanks for watching us. Bye.